Yes.
Yes, thank you, my lord. Great. Over the break, at your lordship's invitation, my team did send you a...
Yes, it's arrived. Thank you very much.
Thank you. It would be helpful for your lordship.
It's very helpful, yes. I think that it looks as if the hotel's the big building near the roundabout.
Yes.
Yes.
Is there a hotel within it, in the complex?
Yeah, there's
see
a
one. I'll have a look.
Now, my lords, just before I take you to the Court of Appeal judgment, I would just like to very quickly...
Just before I leave this hotel point, the hotel is, if you come in from the roundabout and go down the road, it's on the left-hand side, is that right?
It's on the right.
I don't think there is a hotel there at all.
I think no, it's on the right.
There's something called, and what, well, sorry?
Yes, my lord.
Well, which is the hotel? I could see Sue and Joy's and Fisherman's Village Marina, but neither of those is a hotel.
Okay.
But then further up on the left-hand side, if you go back from Fisherman's Village Marina, you get to Resort World Bimini.
Oh, I thought it was the big
that a
curved
hotel?
building at Kayak Beach, but is that just a beach?
No.
No, that's just...
But anyway, in order to get to
Yes, I think so.
Fisherman's Village Marina, do you have to have a pass, a wristband? Or if you want to go to Sue and Joy's, do you have to have a wristband?
Well, we just don't have any evidence
We
about
don't
this,
have
do we?
any evidence.
And the point that I wanted to take your lordships to was simply the evidence of Doug Black at EB 625.
625?
625, yes, my lord.
Yeah.
Sorry, my lord, I'm still managing through the old three-ring binder, so... Yes, so my lords, at 625, your lordship will see, and this speaks to security again. What type of security does the marina provide to their boating customers besides the 24-hour guards? He says, no, that's basically it. There's a security force on the resort, and then the marina staff is here from approximately 7 to 10 p.m. daily. But there currently is no other type of security on the docks. And the security, 24-hour security from the Bimini Bay Resort, and these individual guards, are they responsible also to secure the marine and walk the dock? Do you know? This is the question. He says they walk the docks. Now, the security force actually does at approximately 4 a.m. every morning. They do it, a boat count. It's where they just indicate whether a slip is empty or occupied. So my lord, there is no specific dedicated security staff for the marina. And if I now ask your lordships to turn with me to EB 629, about halfway down to that page, starting with the question from LA. And this is still Mr. Douglas Black, the Director of Operations for the Bimini Bay Marina. He says, let me ask you a question, backing up a little bit.
Sorry, can you give me the page reference again? I'm sorry.
I'm sorry?
Page reference.
EB 629, my apologies.
Thank you.
Thank you. Let me ask you a question, backing up a little bit. In order for a boat owner to come into the marina, board the vessel, and sail away, they need not contact anyone. They can just basically do that on their own will without being questioned by anyone. Douglas Black says they can. Pretty much any marina, unless you have a gated community, which we do not. You can waltz in either by land or by sea and step on a boat and drive it away. Okay, and then he asked, okay, and what is do it? There's no way to stop anybody physically from doing it. Now, some people lost my space, sorry. Now, some people do here, and the previous places I've managed, leave their keys or combination. Now, like other places, I've been assigned out where I've taken your lordships to that before. And the other reference is where his lordship, where Mr. Black says, I'm sorry, I just seem to have lost my page reference, where he says that Mr. Rule did not commit any breach of policy. If your lordships would bear with me, I just lost my page reference.
This was an interview with the investigator.
With the investigator.
Yeah.
Yes, my lord. Yes, and EB 635. Did I just read that?
Yes.
Huh? Yeah, did I just read that? Oh, okay. And then Mr. Alfonso asks, is there any policy set for the Bimini Marina as to how these vessels are to be released to operators at any given time, or there are no policies written in regards to owners coming onto their boats and taking their boats? Mr. Black, owners, no policy. An owner can come and take his boat whenever he wishes. LA, and in your mind, was there any policy violation with regard to the way O'Neill handled the situation? No policy violation, because there is no policy in place that says if you have a conversation with like apparently occurred, the only way he would have been in violation is if they had come in here and asked for a key or combination, and he had failed to fill out the proper form and make the proper identification. But that was not the case. Then he says, so there's no documentation to be prepared for any individuals to come here and take a boat. Is that correct? That's correct. Or to ask a boat hand to prepare a boat to be used, that is correct. So, my lords, that simply demonstrates what in practice occurred at this marina. Now, I would like to take your lordships to the judgment of the Court of Appeal. And I believe your lordship should have that in the key. There's an index to a key documents bundle that was prepared, but it's in the main bundle at 1169.
I assume there's no issue about the law of the Bahamas in relation to these matters being different from English law, is there?
No issue. No
That's
issue.
common ground. Thank you.
Now, my lords, going to the Court of Appeal judgment. And para 26. And I only come here, my lord, para 26 is your lordship's decision in the Bahamas Air Holdings case.
Is that another name for the one we've looked at? A different case? Different case.
I'm sorry, my lord?
We haven't seen this case.
No, my lords. This is the case that essentially governs. I'm sorry, my lord. Paragraph 26 to 29. Yes, when Justice Isaacs deals with the Bahamas Air case, which is the case.
So this is just about what attitude you take to findings of fact.
Yes, precisely.
Oh, right. Okay.
And the principle of restraint that the
Right.
Court of Appeal ought to apply when reviewing the findings below. Now, we say, my lord, that the Court of Appeal acted entirely appropriately in how they dealt with the judgment of Justice Winder. They acknowledged the appropriate authorities, which was the Bahamas Air case, and as Justice Isaac says in rather colorful language, he says, with your lordship's rebuke ringing in his ear, he proceeded to review the findings of the judge below.
Well, he slightly forgot it at the end of his judgment because he went off on a frolic about the boat might actually have been stolen by its owner.
Yes, he did go off on a bit of a frolic, and that's not directly germane or part of the ratio of the decision itself.
Yeah. No, I know.
I think you would say it was an acknowledged frolic.
I'm sorry?
It was an acknowledged frolic.
Yes. That is correct, my lord. So they overturned Winder's finding of a duty of care being owed, primarily on the basis that this was contrary to Clause 17 of the boat slip lease agreement, which Justice Winder did not address in his judgment at all. And at paragraph 103,
They don't really overturn a finding of the judge because he didn't really reason it. So if you assume responsibility based upon a whole series of facts that you found, he's found no facts. And so there's no overturning of any facts that I can see so far.
well, my lord, that is putting it a bit higher than I would put it, but I accept that wholeheartedly. Our position really was that given the absence of dealing with Clause 17, which is the critical and central feature of the case and the dispute, it was open to their lordships to intervene in this particular case.
Well, I find it hard to attach the importance to Clause 17 that you say should be attached, but why is it critical to the dispute?
Well, my lord, it's critical to the dispute because it addresses the specific issue as it relates to the existence or non-existence of a duty of care. The duty of care that was found by the learned judge is simply but diametrically opposed to Clause 17 of the lease. And I'll take...
I'm not sure that's true. I mean, Clause 17, the tenant is undertaking responsibility to keep his boat locked, in effect. I don't see that that is inconsistent with it wouldn't have been inconsistent with the marina undertaking to provide security at a wider level for boats in the marina. It seems to be more important in this case that they didn't actually do that.
Well, my lord, I would respond in this way. The duty that the learned judge found spoke specifically to preventing theft. The BSL Clause 17, on which we rely, speaks specifically to preventing theft.
Well, the boat owner owes, well, he owns the boat. He's got a duty to look after his own property.
Yes, my lord.
And the clause says that he has a duty to look after his own property,
Yes, my
which
lord.
is stating the obvious. But it doesn't exclude that the possibility that the marina also has an obligation in that respect.
It may not specifically or directly do that. The question, my lord, as I see it, is the acknowledged processes of the marina, and those processes would be found in the boat slip lease agreement. Those acknowledged processes, most certainly the marina has a responsibility to ensure that its own processes are implemented without negligence. Its own processes. And
You're on stronger ground, as far as I can see, say they haven't pleaded a case of assumption of responsibility.
no, they have not.
And they haven't identified the facts upon which they say that your client has assumed responsibility.
Yes, my lord.
You can fill in the blanks a bit by saying that your client's provided a security service, and you say, well, the security service is limited. It's only to prevent vandals and
Yes, my lord.
and so on.
Yes, my lord, absolutely.
And there's no assumption of responsibility to prevent theft.
None at all.
Yeah.
And the annual the daily boat count is presumably as much a management matter to see which boats have gone and which boats have come as an anti-theft matter.
Yes, absolutely, my lord. Absolutely. And realistically, it could not directly address theft because it could only record that a theft had occurred. It couldn't assist in preventing it.
There's a remarkable lack of factual findings as to the actual layout of this marina. There are no gates at all, either on the pontoons or at the entrance.
Yeah, and I think the evidence of Mr. Black is that is common with all marinas unless you are in a gated community.
I'm not entirely certain about that. Anyway.
So, my lords, at paragraph 103 of the judgment of Justice Isaacs, and I'm at electronic bundle page 1210. Justice Isaacs says the conclusion of the judge at paragraph 7 of his judgment, and he states what the judge said. I accept that the defendants as the owner and operator of the marina, providing dockage and other related services to slip owners, owed a duty of care to such slip owners. The duty, however, is not the absolute duty to prevent the theft of the vessel, but rather the duty of taking reasonable measures or care to ensure that the vessel is kept reasonably safe and not susceptible to theft. Cannot be sustained in the face of paragraph 17 of the BSL, because it places the responsibility to prevent theft of the vessel on the respondent. The tenant is responsible, and he just repeats the clause. Now, my lords, if I turn over to the judgment of President Barnett, which is at just over leaf, it starts at 1211, but I'll take your lordships over to paragraphs 113. President Barnett reasoned the case on a more narrow basis and more succinctly, although he says that he agrees with Justice John Isaacs. He says from paragraphs 113 onward, and after referring to clause 17, he says, by that clause, the parties agreed that the duty of care to prevent a theft of the boat was imposed on the boat owner and not the marina. This is not surprising, given the marina did not have the keys to the vessel and had no control over the vessel whilst at the marina. The marina's obligations were those imposed upon it by the terms imposed by the written lease. there is nothing in the written boat slip lease which imposes an obligation on the part of the marina to provide security for the boats in the marina. More particularly, there is nothing in the written lease agreement which imposes an obligation to provide reasonable security to ensure that the vessel remains safe while docked at the marina, as pleaded in the statement of claim.
Well, that's a rather broader and, it seems to me, more important point than, in a way, than just a narrow basis of relying on clause 17.
Yes, my lord. And here, the learned president was simply extrapolating, really, what was in the statement of claim and how the claim was moved below. And then he goes on at 116, says, indeed, such a provision would be inconsistent with the specific provisions in clause 17 of the fourth schedule, cited above. To imply such a term would be a breach of the cardinal rule referred to above. As Isaacs J. noted in his judgment, the trial judge did not address his mind to the provision of clause 17 of the fourth schedule. Due to that omission, I am satisfied that the trial judge erred when he found that the marina was in breach of duty to take reasonable care to prevent theft.
If you look at paragraph 111, I'm not entirely convinced that's correct. No basis for implying a duty of care imposing a tortious obligation where the contract imposes a contrary obligation. I don't see it being a contrary obligation. The clause 17. It just states the obvious. The boat owner's got to look after his own boat. It doesn't say anything about what the marina's got to do.
When he says in the 113 was imposed on the boat owner and not the marina, you don't get and not the marina from clause 17.
Yeah.
You get that by looking at the rest of the agreement and not finding it.
Exactly.
Yeah.
Yeah.
I mean, is your case that when you've got a lease where obligations have been put on either the tenant or the landlord, a clause like clause 17 is making it clear that there's a risk, it's a risk allocation device.
It is, yes, my lord.
It's saying, as between the landlord and the tenant, it's the tenant
Yes, my lord.
who bears the responsibility. That's your case, is it?
Yes, my lord. Yes, my lord.
If we weren't with you on that, I mean, you're saying, well, the Court of Appeal was entitled to reject the findings of Mr. Justice Winder because he hadn't looked at clause 17 at all.
Yes, my lord.
Even if we weren't with you on that, isn't it, in any event, a strong argument on your side that a decision as to whether there's a duty of care is a question of law?
It is, my lord.
It's not a question of fact.
No, it is, my lord. You're absolutely right, my lord. And of course, we say, as we've indicated in our written case, we say that in this particular circumstance, there was simply no justification for extending a duty of care to a marina. And the other side, my lord, has produced no authority, despite, I'm sure, diligent searches, that a duty of care has been imposed in similar situations. The airport authority case most certainly does not provide any support at all, because that case was very specific to a regulatory agency performing statutory functions of security at the airport. It was a self-contained property, and the mechanism to get into a plane is rudimentary. And their lordships found that once you get through the gate, getting into an airplane only requires, I believe as Lord Kerr said, rudimentary knowledge. So there was some priority on ensuring that the exterior security was was enforced and was strong, which is not the case in the marina. The primary defense to the theft of a vessel is a secure locking system on the vessel. So, my lords, we say that the Court of Appeal was entirely entitled to take the steps that it did, and in the way it treated the judgment of Justice Winder. I would now like to turn to considering the construction point of Clause 17 itself. And your lordships will find it at EB 70.
It's also open on the page we're at, which is 1212, I think, isn't it?
Oh, you mean
It's quoted at paragraph.
yeah, reproduced by the court.
Yeah.
Yes. Although I did want to take your lordships to other clauses in that lease as well,
Okay.
so that your lordships could see in the full contractual context why we say that this clause most certainly allocated a responsibility and the risk of theft to one of the parties of the lease. Now, my lords, clause,
Page.
page EB 70.
Q.
Yeah, I'm sorry about Lord Barrows. Your lordship will see that clause is a part of the fourth schedule to the lease. And that fourth schedule, which is at EB 69, is headed Restrictions and Regulations Imposed in Respect of the Boat Slip and Access. And if we turn over the page to paragraph 9 of that schedule, it reads, the tenant agrees to tie up any boat or craft, hereafter referred to as the boat, utilizing the boat slip in a safe and proper manner, so as not to damage the boat slip or other boats in the marina. And then it goes on to say the tenant shall keep...
So which point number are you reading now?
Oh, I'm sorry, 9.
Point 9, I think.
Yeah, point 9.
Yep.
And then they say the tenant shall keep all gates and docks for which the tenant is given keys locked at all times. The key provided is not to be duplicated or transferred. Upon the determination of this lease, the tenant shall return all keys. Then it moves on to say the tenant agrees not to block or obstruct other boat slip owners.
Well, is there a key to get onto the pier, for example?
No,
You have to go, nothing like that.
yeah, there's no key to get onto the pier.
So what keys are we talking about that the tenant is given?
There's simply no evidence, I think.
Well, there's nothing, we don't know anything about any such keys, do we?
I'm sorry, my lord.
What's the relevance of point 10? Some keys that the tenant is given, and he has to gates and doors that he has to keep locked. We haven't heard anything about that.
And I guess this would only be Millard's speculation, but it probably relates to entering the common areas of the marina.
Well, that's part of the difficulty. We just have not the faintest idea as to the layout of this marina, where the hotels are, where the shops are, where the restaurant is. There's no analysis as to who can get access to the hotel without actually having to go past a security gate or whatever. There's no description of the actual jetties themselves.
No.
One goes over there, right? My lords, if I can ask you to turn to clause 1, which is on EB 54. Clause 1 deals with the grant of very broad access rights to the boat owners and their guests. Again, which is consistent, my lords, with the free flow of people in and about the marina.
Where are you looking at?
Oh, clause 1, EB 54. EB 54.
Mm-hmm.
This is grant. It says in pursuance of the agreement. And
Which particular bit?
Oh, I'm sorry, my lord.
Which particular part?
Yeah. If you come across it, it grants the easement on the right. Mm-hmm. It says first all that boat slip at the very bottom. First all that boat slip, numbered 16 Dolphin, situated in the marina. And secondly, full free right and liberty for the tenant, his or her agents, servants, visitors, and licensees, in common with the landlord and all others who now have or may hereafter have the like right, at all times hereafter, by day or by night, with or without animals, on foot only, for all purposes connected with. So it's a broad grant of access to the boat owner and his guests.
And his licensees and his servants and visitors.
Yes, Lord.
A licensee is essentially, so long as it's for a qualifying purpose,
Yes, Lord.
would include almost anybody potentially.
Yeah. Mm-hmm. And there would be no contractual right to stop them.
To stop them, my Lord. And then if I take your lordships to 2.8.
So long as it's for a purpose connected with the use and enjoyment of the boat slip.
Of the boats.
Yeah.
Yeah.
And then if I go over to EB 59, my lords, and paragraph 8, says, except as hereinbefore provided, not to allow the benefits of this lease to be used by anyone other than the tenant and his immediate family members, Notwithstanding the foregoing, the tenant may allow guests to utilize such slip on a short-term basis defined as no more than 5 days per month, provided that there are no rents or other fees engaged by the tenant in connection with such use. Again, my lords, a clause that is permissive and facilitative of persons visiting, coming, going at the marina.
And that means with their boats, I think, doesn't it? In other words, he can say, I'm away for a week, you can bring your boat in for 5 days.
Precisely, Bernard.
Yeah.
And it's what it's what the marine operator, Doug Black, described as transients, and he says there's no way to control them. And very helpful in that would be the evidence of the dock master. If I can take you to that, he is at, where is I put that page? Mr. David Rule, he's at 696 to 726.
Sorry, I missed the page number.
Oh, I'm sorry, my lord.
Sorry,
This is the witness statement of David Rule. It starts at 696. But I will take your lordship to paragraph 8 of that statement over on 698. Paragraph 8. And this is David Rule, the dockmaster. He says, while Bimini Bay provides security personnel generally for the Bimini Bay Resort, and in their patrols, these security guards do in fact patrol the marina. The mere patrolling of a marina can never be effective to prevent the theft of a vessel if someone is intent on stealing a vessel from the marina. Boat owners and their guests are constantly walking up and down the docks at the marina and entering and exiting vessels. Marina staff of a busy marina could never be personally familiar with each boat owner, some of whom only visit occasionally, whose vessel is docked at the marina. The only way to secure a vessel from theft at a marina is to ensure that the vessel has a very secured locking system and that it is kept locked at all times. And then he goes on to say this was obviously not the case with the vessel, as the persons who took the vessel either stole or obtained the keys from Mr. Modrono, or someone who in the ordinary course of their relationship with Mr. Modrono had access to the keys for the vessel. The only other possible scenario, was that the vessel was left unlocked by Mr. Modrono, as the marina did not have keys for the vessel in its possession. Now, my lord's critical to that.
I mean, it's fairly casual for Mr. O'Neill Roll just to accept money from somebody who calls him up on the cell phone and arrange somebody to clean a boat without any attempt to verify that it actually belongs. He collected $400 and paid somebody $250 to go and clean the boat.
Yes, my lord. Bearing in mind...
Even if they had no duty at all apart from this, once Mr. O'Neill Roll gets the phone call, wouldn't you expect him to do something to check that he's actually speaking to a person who has any authority to have the boat cleaned?
No, my lord. No, my lord. Not given his level. Mr. O'Neill Roll is a porter, a dock hand.
We never know how they came to have his cell phone number.
No, we don't know how they came to have his cell phone number, my lord.
All right. does seem to me to be the one area of the case which doesn't look very happy from your client's point of view.
Well, my lord, again, if given O'Neill Roll's status as a dockhand, it's virtually akin to a janitor.
Well, janitors don't. I mean, it's one thing if he just sat in his office, but he actually accepted money to do things in relation to the boat, with no idea who it was he'd spoken to, apart from the man say so.
Yes, Muller, that's the facts. I mean, there's no way for us to get around that.
It's the sort of thing you lose your job for, I would have thought.
Yeah, and actually he did. He's no longer the
Yeah, exactly.
He actually left shortly thereafter.
Somewhere in the slip lease, and I can't now remember where, I think it says that porters or people on the dock are not meant to do paid private
Correct.
work
That's in the
for boat
lease.
owners.
That's in the lease, Muller.
Yes, I'm struggling to find where it was,
Yeah,
and I can't find it. But
Was he a porter?
it rather
Was he-
suggests he was on a frolic of his
I'll
own
find
in doing a private job for a boat owner anyway.
Yes, he would be. Yes, Muller.
Because if he's one of those persons, but I can't find the clause in the
Yeah,
lease.
I'll
I'm
find
trying to remember to whom it
I don't have it.
3.6, page 3, clause 3, subclause 6.
Yeah.
3.6.
Yeah.
Yes, the tenant shall not employ the porter or porters to perform any special services for the tenant. It's funny, they're called a porter, they don't seem to do porterage.
What do they?
Well, they seem to be employed to cleanse common areas. It's 6 little a and little b, which is removing the rubbish and keeping the areas clean and the lighting working. Attend to the lighting and extinguishing of the lights. Not unfortunately carrying your baggage to and from your boat.
No.
Wouldn't that be wonderful? I mean, is Mr. O'Neill Rolly one of those persons?
I don't think he is, isn't he?
No, they would have other
He sits in the office, doesn't he, Mr.
I'm sorry?
I don't know. What did he do, Mr. O'Neill Roll?
Oh, he was a porter. Lift ice to pick up ice for vessels, clean out the garbage.
Oh, he did. He was one of those people, was
Yeah,
he?
he was one of those persons. Yeah, he was in the David role that sat in the office.
So he was stepping outside his job description to take private.
Yeah, he was
jobs for
freelancing.
boat owners.
Yes, my lord.
Yeah.
Yeah.
What consequences to that?
So, my lords, we say, given the broad right of access that boat owners and their visitors and guests have, it would virtually be impossible to be able to control the access of persons walking around the marina. You couldn't stop a boat owner who was coming in and is going to decide to go on a joyride and bring a friend or guest. There's no checkpoints where a porter will come up to a boat owner and say, so where are you going? Where's your ID? I mean, in the context of marinas, it simply doesn't work that way.
It could work that way.
Oh, my lord, I'm not sure it could, not effectively.
The owners wouldn't be very impressed with that sort of service.
No, they wouldn't. They wouldn't.
It could work in marinas where you had to lock in and out, but
Yes.
this isn't one of those marinas.
No, it's not one of those marinas.
No.
It is not one of those marinas. It was never represented to be one of those marinas.
No.
So, my lords,
Well, there's a limit to what one can say, I would have thought. I mean, was a marina where they didn't promise to keep your boat secure, and that's about all that there is to it, isn't it?
my lord, I'm not that courageous.
Well, you seem to be. I mean, that's the point you're making.
That's
various different ways, but
yes, my lord. And again, I won't take your lordships directly to the papers, but the situation at the marina is akin to the decision in the Halbar case that the Court of Appeal relied on.
Lord Denning's.
Lord Denning's classic exposition of the law on it. During the summer, when the caravan was closed in and protected, there was a duty owed. During the winter, I'm sorry, I do just corrected me. During the winter, there was a duty owed, and that authority, just for the benefit of the board, is at, sorry, 1535. And perhaps I'll just take your lordships very quickly to it. Because that is virtually identical to the scenario we have here. Sorry.
So you say this is the closest analogy, and if one wants to argue by analogy, this is the closest.
This is the closest analogy, absolutely, my lord. And in this analogy, the law determined that it ought not extend a duty of care to this type of situation. And if I take your lordship to page 1540, well, actually, I'll just start from the very beginning of Lord Justice Denning's decision on page 1539. Where Lord Justice Denning says, during the summer months, the corporation gave to each camper a license to use a caravan site for 25 shillings a week, which payment carried with it the right to use the facilities of the camp. The corporation did not let the site on a tenancy. They only licensed the camper to use it. They did not take possession of his caravan so as to become bailies of it. The camper remained in possession of it himself, and it was for him to take care for its safety. The corporation, as the camp authority, were no doubt under a duty to use reasonable care in their own sphere of operations, and we accept that, my lord. If their servants negligently ran into the caravan, they would be liable for the resulting damage. If they negligently allowed the camp to become filthy and insanitary, they would be liable for the resulting disease. But their responsibilities did not extend to locking up the caravan or chaining up the wheels so as to prevent their theft. That was the duty of the camper himself. The camp was open day and night throughout the summer, with campers and their friends coming in and out, with and without vehicles, without let or hindrance. In these circumstances, the corporation could not be expected to be responsible for loss or damage to property not caused by them, and they were not in law responsible for it. In my opinion, Condition 8 does no more than express the legal position as I have stated it. It is a warning to campers that they must take care of their own property. As such, it is unobjectionable. It would not protect the corporation from their own negligence, for example, in running into the caravan. During the winter months, the position was different. The camp was closed. The road gates were kept locked, and the caravans of customers were parked on the hard tarmac. The corporation described them as being stored and made a storage charge of 12 shillings a week. None of the camp facilities were available. During these months, I think the corporation were bailies of the caravans and responsible for their safe custody. If the corporation negligently left the gates unlocked so that a thief came and stole one of the caravans, they would be responsible. I do not think that Regulation 8 would protect them, because that, I think, only applies to the summer months when the campers are using the camping grounds. In any case, I do not think that it is sufficiently clear to exempt them from their common law responsibilities. My lords, if I was to argue by analogy, I would say the summer months is a situation where the marina held the keys for the vessels. The winter months is the situation that pertained to these appellants, because the marina did not keep keys and they could come and go as they
Other way around, I think.
Oh, sorry.
I think you slipped below the equator for a moment.
Yes, I did. My apologies. The other way around.
The idea of winter and summer in the Bahamas starts to become a little...
Well, actually, we almost only have summers. I'm sure my lords have my point. So my lords, and another authority that we think is germane is the decision in King's. What page is that? 1637. Yes, yeah, the King Liverpool City Council case. And if I can invite your lordships to turn to page 1637. It's probably helpful, my lords, if I read the head note. Just above the letter D, says the trial judge, having found that it would not have been possible for effective steps to have been taken to defeat the activities of the vandals, held that the defendants owed the plaintiff no such duty and dismissed her claim. On the plaintiff's appeal, held dismissing the appeal, that although there was no principle of law excluding liability and negligence for damage caused by the deliberate wrongdoing of a third party, liability would only attach where there was some special relationship between the defendants and the third party, or where possibly the injury to the plaintiff by the third party was the inevitable and foreseeable result of the defendant's acts or omissions. That the fact that the defendant was unable to take effective steps to defeat the actions of the vandals operated to restrict the ambit of the defendant's duty, so that in circumstances the defendant owed no duty to the plaintiff to take any steps to secure the vacant premises. Now, my lord, what we say here, and I'd taken your lordships earlier to the statement of Doug Black, the marina operator. The duty that was imposed by the learned judge below was a duty that an active marina can simply not comply with. Unless they were in a fully enclosed, gated community. And given the peculiar nature of this marina, there was no steps that the marina operator could have done or could have taken to prevent individuals coming into the marina, walking onto boats. Now, a bit was made about wristbands, and of course we say that case was not run below at all. And without prejudice to that general point, there is nothing to say that an individual wearing a wristband wouldn't steal a vessel.
Well, we simply don't know how the wristband system operated, do we?
No, we don't, my lord. And like I said, it was not run below, and I just make that statement without prejudice to that general point.
Well, you can't really make that assertion because we don't know how it worked. If the system was you had to show that you were the owner in order to get a wristband, then I think it might have operated quite effectively. But we simply don't know that, do we?
We don't know that.
And how does this case, the Liverpool case, tie in with the King against Liverpool, tie in with the more modern approach of an assumption of responsibility?
I'm not sure it will be decided the same way.
Yeah.
We're just debating whether the Liverpool case might be thought to have passed its shelf life.
Oh, I understand, my lords.
Yeah.
I understand. But again, the point was being advanced so to establish that where you have a situation where you cannot take effective steps to prevent something from occurring, you ought not to impose a duty in respect of that something.
But it might make it less likely that you're going to assume a responsibility if there's nothing you can do.
Yeah, right.
That's about it.
Now, my lords, let me turn in the 30 minutes I have left, and I'll try to keep your lordships too long, to the position by the...
You might want to give your junior a moment or two to follow.
I'm sorry. Yes, my lord.
I wasn't suggesting 30 minutes.
I will, my lord. What we're going to take on is... Yeah. What we're gonna take on
Yeah, maybe.
And the idea that you can't keep a flat I know these days doesn't make sense. It may have done in those days.
True. It was exactly the same argument run in Belfast as various organisations were.
all right. I'm just confirming, my lords, that might you wish to take your lordships on. But my lords, what we'll turn to, and I'll have Mr. Bradford address your lordships on the point, is the appellants have taken the position that the clause, which we say is simply a clause allocating risk and responsibilities amongst the parties, they have taken the position that that is in effect an exclusion clause, and that the exclusion principles for construction apply. You know, and we say that's absolutely not right. So I'm going to yield to my junior to have him make that point. Yeah, I'll come back. I'll come back.
The point you've just made, you mean?
I'm sorry.
I'm sure it'll be done very elegantly.
Thank you, my lord. I'll take the point very quickly, but it's simply to elaborate on. Thanks. And to elaborate quickly on what Mr. Wilson has just said, and it addresses specifically ground one of the appeal as it's been put in the appellant's written case. And you'll find the appellant's written case, my lords, at page 1265 of the electronic bundle, paragraph 66 to 70. I'll just take the point really quickly before yielding back to Mr. Wilson. Essentially, the argument, which we say is a straw man argument of the appellant, is to say the Court of Appeal construed this as an exemption clause and therefore applied, or failed, or erred, because they didn't apply the correct construction principles in relation to an exclusion clause. The problem with that argument, and the reason why it's a straw man, number one, first point, my lords, is that they didn't construe it as an exemption clause at all. In fact, Lord Justice Isaacs was very careful and very explicit to say this wasn't an exclusion clause. And I can take, my lords, very quickly to the page and paragraph of the Court of Appeal judgment where that's found. And that's at page 1195 of the electronic bundle, paragraph 53. Where Lord Justice Isaacs very carefully says, this is not, well, in the interest of time, I won't read the whole passages, but it's at paragraphs 52 and 53 where Lord Justice Isaacs says it's not an exclusion of liability. And the second point that I would make in relation to the appellant's respectfully straw man argument and why those cases don't apply is because as a matter of principle and as a matter of sort of theory, an exemption clause does a different thing. It seeks to exclude liability altogether. And therefore, there's a good reason, it follows why the courts might apply a different standard of construction principles in relation to a clause which purports to do that quite extreme thing. This is not the inquiry that's taking place here. The inquiry that is taking place here is in light of the entire contract, with particular reference to clause 17 and taken in as a whole, looking at the rest of the clauses, is that contract and the allocation of responsibility inconsistent with the duty of care as formulated by Winder below? And of course, my lords, we say it is. So for that reason, my lords, we simply say that ground one as formulated in the written case simply falls away because it proceeds from the wrong premise and then seeks to apply the wrong principles to it, or seeks to apply inappropriate principles to the exercise that is actually being conducted here. And with respect to my learned friends, the highest that they address these points and the principles that we say are relevant is at paragraph 67, electronic bundle reference page 1265.
Electronic Bundle 1954. Yeah, 19. No.
You seem to be in the right case. Which paragraph did you want to go to?
Hold on. Oh, Para 43. Yes.
Yeah.
Electronic Bundle 1955. Para 43. And this, this a somewhat similar situation dealing with liabilities in tort and rights and obligations in contract. And Madam Mrs. Justice O'Farrell said, the above cases were concerned with the question whether there was any duty of care based on an assumption of responsibility. But that question necessarily involves a determination of the nature and scope of any duty of care. A bare finding that a party owes another duty of care is meaningless in the absence of a finding as to the nature and scope of such duty. In a commercial context, the nature and extent of a common law duty of care will be framed by the contractual nexus or lack of contractual nexus between the parties, together with the wider factual and contractual arrangements, including any stated limitations or exclusions from liability. The cases all serve to emphasize the importance of the factual matrix when considering whether any common law duty of care arises, including the nature and scope of that duty. And as we say that, that is the exact assessment that needed to be done and that the Court of Appeal did. There's another authority, my lads, and that is the Greenway versus Johnson authority, which is at Electronic Bundle 1533. And in advance of one of your lords pointing it out to me, I'm aware that case has in fact been overturned, but it was overturned on a different point. And it does not impact the point that I wish to make in that case, which is at Para 49. Yeah, 1533. Electronic Bundle 1533, Para 49, and this is the decision of Lord Justice Sales. He says, the policy arguments relevant to implication of the duty in contract and imposition of a duty of care in tort were closely similar. This is significant. Where the nexus between the parties is founded in a contractual relationship, as here, it is the contract which they have made with each other, which is the primary source and reference point for the rights they have and the obligations they owe each other. Although a duty of care in tort may run in parallel with the contractual duty and have some content, it is difficult to see how the law of tort could impose obligations in this area which are more extensive than those given by interpretation of the contract, which the parties have made for themselves.
My difficulty with that is that is exactly what occurs in relation to contracts for private health treatment. I can see, and obviously the contract is one of the facts you take into account, right. but I don't think it's sufficient to say that only an assumption of responsibility that's contained in the contract can be given effect. It's all the factors.
All of the factors. I would accept that, my lord. And just in concluding, it says the usual rule is that freedom of contract is paramount, and if the parties have agreed terms to govern their relationship which do not involve the assumption of responsibility by the employer for some particular risk, the general law of tort will not operate to impose on the employer an obligation which is more extensive than that which they have agreed.
Occurs in every single private
I'm sorry, my lord?
It rather depends on the context, doesn't
Yeah.
it? Because sometimes you might have a very detailed contract between the parties, and the inference is that that's intended to be definitive of the scope of their obligations. In other cases, it's just a very broad contractual arrangement, and it may be filled out by the way they actually deal with each other, for example.
Yeah, absolutely, my lord. Absolutely, absolutely. And of course, we say in our case that, you know, it's not broad and general, it's very specific.
Well, in your case, you actually provide a security guard service. What are the contractual terms in relation to that?
I'm sorry, my lord?
You provide security guards in this marina, and I can't now immediately recollect where the contractual obligation is to do so.
Well, my lord, the security...
So the facts are filled out by what you actually do on the ground, and so you can look to see what the parties are actually doing.
Yes, my lord.
And then see whether there's an assumption of responsibility to provide security guards, or an assumption of responsibility to provide security guards to prevent theft, which is an entirely different thing.
Yes, my lord. And again, we say if an assumption of responsibility can arise in any scenario relating to this BSL, this lease agreement, it most certainly would not be as it relates to preventing theft, because the clause speaks specifically to that. Minute, my lords, I just want to check with my team to see if I need to address your lordships on anything else. Thank you. My lords, that is the case for the respondent. I'm grateful for your lordship's indulgence.
Thank you very much. You're content with that, are you, Ms. Archer?
Yes, we agreed that, my lords.
Very well.
Yes.
Just to deal with a couple of factual evidential matters first. My learned friend took you to part of the evidence to suggest that the checkpoints were simply a means for the guards to check in on their rounds. And that's not actually correct, and it's certainly, at least, contrary to how the respondents put their case before the Court of Appeal, which is, of course, referred to in paragraph 62 of the Court of Appeal's judgment, and that's at 1198. So this is what the appellant said. This was the appellant's case before the Court of Appeal as to their security measures.
So which paragraph are you in?
62, 1198.
62, yes, I got it.
They provided significantly more security than the defendant in Taylor, inasmuch as the marina was patrolled by security guards, etc. And access to the marina was restricted by security checkpoints. So that's the appellant's case as to what the security checkpoints were used for, to restrict access to the marina. And the Court of Appeal rejected that, as I said earlier, by saying, despite the checkpoints, persons were able to access the property freely. The same goes for the respondent's other assertion to your lordships that there was no dedicated security staff for the marina. Again, that's contrary to the pleaded case at paragraph 8 of the defence, which is at page 27. Your lordships have looked at that, but just to recall, it says the marina was secured with security guards. And one other small evidential point about whether there's a difference between a dockhand and a porter. That was raised actually in oral evidence with Mr. David Roller, who'd pointed to that phrase in the lease and said porters shouldn't do this, and he was asked the significance of that in oral evidence at 869. At the top of the page. But he cleared up his evidence over the course of that page. If you go to the top of 870, he ends up telling us that porters and dockhands were different. Oh. And that's the top of 870. He's not a porter, he's a dockhand.
Porters are people which come to the marina.
That doesn't sound like he's using porter in the way that it's used in the lease.
No.
Because porters in the lease are people who clear away the rubbish.
I should say that we pleaded that Mr. O'Neill Roller was a porter/dockhand.
When is a porter?
I may not have cleared anything up for your lordships there. And just on the, my Lord Logan's point that we don't know how the wristband system operated, I've shown your lordships this before. I've shown your lordship Mr. Modrono's evidence. That is evidence as to how the owners thought the wristband system operated and what effect they thought it was supposed to have.
So whereabouts are these wristbands put on? Whereabouts, at what point?
Mr. Modrono said they were put on when they checked in.
Whereabouts do they check in?
There's an office in the marina where you check in.
Is that different from the entrance gate?
Apparently so, yes. Yes, my lord.
Right.
Because the evidence was the entrance gates weren't manned to
And you expected all owners to go to the office in order to check in and
What's the reference for that?
the evidence is to Mr. Modrono checking in with the wristbands.
And that checking in wasn't just when he arrives on his boat, it was me checking in, was it?
I'll see if we can find that. It may have been in his longer. Yeah, well, it may be gleaned from what he says to the Court of Appeal at 1196. How the Court of Appeal reported it.
The thing is, there wasn't really a proper case about this, was there? I mean, it was just asked about it in evidence, and he made some comments, but if you're going to make an argument that there's a wristband system, you have to do a bit better, really, I think. And there was no finding by the judge about such a system.
It's
so
true.
At this stage, it's not really going to...
Yes, fair enough, my lord. It was raised before the Court of Appeal, which is why they refer to that evidence.
Yeah.
But
If you're relying upon the de facto security system as a kind of assumption of responsibility, which I think you are, isn't there an element of hauling yourself up by your own bootstraps in saying, well, they had a security system, it was a pretty awful one, it didn't do what a good security system might have done, namely help protect the boats from theft, and therefore they're liable for not having a better security system than the one they actually assume responsibility for having?
well, I'm not sure that is a bootstraps argument. It depends on, first of all, as I've pointed out, the owners relied on it. They believed that people weren't allowed access to the marina unless with wristbands. And it also emphasises that the marina could have, and therefore had, sufficient control to prevent unauthorised people from accessing the boats.
I think if that was going to be properly argued, it should have been pleaded, or even if not pleaded, it should have been led in the witness statement, and the defendant's witnesses should have been cross-examined about it, but there's none of that really. It's just a bit of evidence.
Although that's, I accept that objection. For the duty of care, let's concentrate on the judge's findings. And I should point out, it occurred to me that in addition to what he said in paragraph 7, it's also necessary to consider what he said at paragraph 19, which is page 48. Because that's where he decides that it would be unreasonable to exclude such a duty of care. And so I think one can infer that the reasons for saying it would be unreasonable to exclude it are the same reasons for saying it would be reasonable to impose it, or at least are related to them. And so you'll see at paragraph 19, he accepts the submissions of the respondent as to the factors relevant to that question. So one ought to consider those when one's considering the judge's reasons for finding a duty of care in that situation.
So I'm still slightly at a loss. You're relying upon an assumption of responsibility, as I understand it. Or, first of all, you're relying upon an analogy with the airport case, okay? And then you're relying upon an assumption of responsibility. And the assumption of responsibility is based upon what?
Well, perhaps I'd rather take it by looking at what the judge focused on, and he focused on the actions and omissions of O'Neill Roller. So
That's looking at the breach before you look at the duty.
But the breach takes place in certain circumstances where one is asking a specific question. Did O'Neill Roller have a duty to challenge these thieves?
Okay, so he's got a duty to protect the boat owners from the theft of their boat.
Yes.
And that can only arise in certain specific circumstances. One of them is assumption of responsibility. Was there an assumption of responsibility, and if so, how?
Well, I've relied on the scheme of the security scheme that we see, and the owners relied on.
Yeah. Okay.
Now, in addition to that, we know that duties of care in respect of third parties can arise not only because of an assumption of responsibility, but also from a special degree of control over the circumstances.
Well, it's control over the individuals rather than
Yes. Well,
Or over the boat in this case.
yeah.
and there is a special degree of control over the circumstances here because the thieves approach O'Neill and ask him to prepare the boat, and he's there when they take it away. So he does have a control over what happens. Now, if we focus on O'Neill's actions and omissions at that point, and I've said how they contributed to the theft, but the question for the duty of care is whether the marina would have a duty of care in those particular circumstances when an unknown person presents himself as authorized to take a boat away, and whether the marina would have a duty of care to check his authority, prevent him if he was unable to satisfy it. As to
But doesn't that depend upon the marina having the right to refuse to let the boat be taken away? I can quite see in a controlled marina where whether a boat enters or leaves is entirely in the hand of the marina operator, such as one where you have to lock in or lock out. You have that degree of control. But is that in reality something that the marina owner can do in practical terms in a free-flow marina like this one, where people can effectively come and go as they please?
The point was made about the right of way in the lease, that there's no contractual right to stop the access of those permitted to come and go. But the fact that there's a right of way, of course, means it's the marina who controls this property and decides who does have a right of way. And the fact that there's no contractual right to stop the access of those permitted doesn't mean there's no contractual right to check their permission. And if you find out that somebody's there who has no legitimate business being there, you can eject them from the premises. And as for what happened when O'Neill met the thieves, I go back to what my first answer is: what impressed the judge. And what impressed the judge was the marina's own report, which said that O'Neill should have checked their authority, and the marina should have a procedure to check it in those circumstances.
Are you saying that it's clear-cut that O'Neill Roller was acting within the scope of his employment? Because if he's not, all this argument falls away, doesn't it?
Yes, I'm saying it is. He's a dockhand on the docks. And in my submission, the respondents haven't addressed that point. They rely on the marina policy, and they say the policy was that boat operators were able to access boats and leave by sea with relative ease. Or the way they put it in their case is that those who had legitimate access to the boats would be able to leave without any process. And that ignores the question that I put. What about people who didn't have legitimate access and who had no legitimate business gaining access to the boats?
No, but the burden of proof is on you to establish the duty of care.
Yes.
So if your case is, at least part of your case, is there was some sort of control exercised by an employee of the marina, then you have to establish that he was acting at that point as an employee of the marina, and that he wasn't on a frolic of his own.
Well, I say
that's your burden, surely.
Yes, but I say that that's made out by the security report saying what O'Neill should have done, and saying what the marina, that's saying that the marina should have a procedure in those cases. And perhaps it is relevant in answer to your Lordship's question that when David Roller was challenged about the piece of evidence that porters shouldn't be supplying special services to boat owners, he said he wasn't talking about, he didn't mean to talk about this specific case because O'Neill's a dockhand, not a porter. So there was no suggestion from the marina's witnesses that O'Neill was not acting in the course of his employment. And I say the security report is sufficient to prove that to establish that he was. So perhaps when I talk about the question, is there a duty of care in respect of those who had no legitimate business? Perhaps the fact that the marina generally could have controlled and restricted their access but didn't is not strongly relevant to that question given your Lordship's objections to how the case was put. But the fact that O'Neill in particular could have challenged the legitimacy of the thieves' access is of great relevance to that question. I was going to address the suggestion that if no duty appears in the contract, then no duty of care arises, but I think that may have been answered by your Lordship's discussion in relation to the Greenway case. We're not looking for a contractual duty of care here. The question whether a common law duty of care arises is answered by looking at all the circumstances, including the contract. In answer to that question, again, I return to what was impressed the judge, which is the security report. And in terms of the Greenway case, on that point, to the extent that the proposition put by the respondents in reliance on the Greenway case, to the extent that's different from the process described by Lord Gough in Henderson and Merritt, then Lord Gough is to be preferred in my submission. One should first articulate the duty arising at general law and then inquire whether the contract's so inconsistent with it that the duty at general law is excluded. And if there's a distinction in the Greenway case, it's that it was talking about an employer's duty of care, a case where the specific relevant duty arose from the contractual relationship. And,
So you say you look at the general common law position first, i.e. in tort, and then contractual aspects may feed into that.
yes.
But that's the right way around.
Yes, and that's the process outlined by Lord Gough in Henderson and Merritt, which is...
What page number? Sorry.
I've lost my page reference, so I'll get there.
Certainly, that seemed to me, my understanding of what you did was you looked at all the circumstances, including the contractual terms, and then you arrived at a decision as to whether or not there was a common law duty of care. And then you can look at the contract again to see whether it definitely excluded it.
Yes, and I agree with that. And if I were to...
And where's the authority for that?
If I describe that as Lord Gough's process, I'm referring to Henderson Merit, which begins at 1544, but the relevant passages begin at 1592, which is 193B. Now here he's talking about tortious duty arising from assumption of responsibility, but the process has been approved as right in other examinations as to tortious duty. Approached, so just as B becomes C, approached as a matter of principle, therefore.
I've got the wrong page number. Where are you?
1592.
Thank you.
It's within the internal pagination is 193B and C.
Yeah.
So you establish whether there's a tortious liability, and then inquire whether or not that liability is excluded by the contract. And over the page, Lord Gough says what he means by that, 194A to B, is whether the tortious duty is so inconsistent with the applicable contract that, in accordance with ordinary principle, the parties must be taken to agree that the tortious remedy is to be limited or excluded.
Assumption of responsibility also requires reliance, except for when you're dealing with children. There was no finding of any reliance at all, let alone actually any reasons for the assumption of responsibility, or even a pleaded case of assumption of responsibility.
That's right.
Anyway, but there was no reliance. That's a separate point.
Yes. That's right, my Lord.
Where's the evidence of reliance in this case?
Well, I've spoken of Mr. Modrono's evidence as to how he thought the security systems operated. And it's pleaded, indeed, at paragraph 8 of the defence.
Upon the mariner to take reasonable care to prevent the theft of his boat.
Well, that's the evidence as to reliance.
Yeah, okay.
But speaking about the process of inquiring as to whether the duty exists and is excluded by contract, the answer's there in Henderson. Yeah. And I say it doesn't apply only to assumption of responsibility cases. So, moving on, the last 2 points, just to distinguish the King and Liverpool case. The distinction in that case is that the trial judge found that the defendant couldn't have taken effective steps to prevent the damage. And in this case, the trial judge accepted the evidence that the defendant could have, because O'Neill could have. That's what he means by saying that O'Neill contributed to the theft and facilitated the theft. And distinctions with the Halbauer case, Lord Denning's case. First of all, in that case, the corporation, well, I'm not sure how your lordship's going to take this given what you've said about the wristbands, but in that case, the corporation didn't have a system purporting to identify people who were permitted to be there, to distinguish from those who weren't. But the second distinction is, of course, that it wasn't the case in that case that an employee was there when the thieves took the car away, an employee who would just check whether the car was ready to drive. And just dealing that, if I may quickly move on to the arguments about Clause 17 of the Fourth Schedule. The respondent draws a distinction between clauses which purport to exclude liability and those which allocate responsibility between the parties. I'm not sure that that's a particularly helpful distinction in this particular case, because if it is said that Clause 17 prevents one from imposing on the marina a duty that would otherwise be imposed by the general law, then one follows the process that we've just looked at, set out by Lord Gough. And one still needs clear words or necessary implication to exclude a duty that would otherwise be imposed by the common law. So the question ends up being the same. But in terms of whether this is an exclusion clause, the effect of Clause 17, according to the Court of Appeal, was that it absolved the marina of any responsibility, so that it prevented any common law duty of care arising on the part of the marina. In my submission, that's an exclusion clause. And to the extent that it allocates some responsibility, it doesn't allocate responsibility between the parties. The respondent's error is in treating this as an either-or question. Either the owner is responsible for keeping the boat safe from theft, or the marina is. But Clause 17 addresses owners on matters that are within their control. So the owner is made responsible for matters within its control, and the clause is silent about matters within the marina's sphere of activities and its control. So that's what I have to say about Clause 17. And unless your lordships have any other questions, that's what we have to say in reply.
Thank you very much. Ms. Archer-Glasgow, I imagine you were, as it were, giving up your place to Mr. Strang.
Pardon me, my lord?
You were giving up your place to Mr. Strang.
Oh, yes, but we agreed that he would do the reply and I'll present it, yes.
No. No questions? No. Well, we're most grateful to all counsel for their written and oral submissions, and no doubt to those in teams behind or elsewhere who contributed by their research or any drafting which they may have done. We will take time to consider what advice humbly to tender to His Majesty.